Hi, y'all. It's Daniel again. This is one of my players, B. Scott.
Yeah.
He is a pre-law major and helped tutor me through this Franklin versus Gwinnett County public case. It was very complicated, but I'll do the best I can to help explain it. So in this case, Christine Franklin alleges her 10th grade coach and teacher, Andrew Hill, of sexual assault. Upon further investigation by the school, she was encouraged, her and other students that accused him of sexual assault were encouraged not to press charges and pursue it further, and Franklin agreed to resign if all the complaints were dropped. This action was brought to the district court. They dismissed the complaint on the ground that Title IX does not authorize an award for damages. The appellate court upheld that ruling, and then the appellate court was basically had to review their own ruling, and because the court above them said that they would rule the other way, so it was in the court's best interest to go ahead and review their case again, and they did, and they went with a reversal ruling in favor of the complainant. Really, to understand this case, we have to understand the case of Cannon versus the University of Chicago. The Cannon versus the University of Chicago set the precedent that a Title IX suit is a... So to understand this Franklin versus Gwinnett County case, we have to understand the Cann versus the University of Chicago case, which set the precedent that through Title IX there's an implied right of action, and through the implied right of action, as long as the Congress and the laws say nothing about denying a chance for remedy for the complainants, then the remedy should be awarded. In Cannon, the court held that Title IX is enforceable through an implied right of action, and that remedies are available in a suit pursuant to an implied right. So this means that if there is an implied right, even though it's not actually written down, it's something that we should assume that they have the right for monetary damages, is what the Franklins are trying to argue. In the federal court system, where legal rights have been invaded, the court can see fit to make amends through remedy for any wrongdoing that was done to the complainant. Since Title IX is a federal offense, this was the Franklin's family's argument. The Franklin family was arguing that this was an intentional violation of Title IX by the school, which is who they were going for the monetary settlement from, because the Gwinnett County or the Gwinnett High School discouraged them from making any type of suit and kind of just let the situation dismiss itself rather than taking control of the situation. The ruling set in Cann versus the University of Chicago was based on the precedent set by Marbury versus Madison, where Chief Justice Marshall observed that our government had been empathetically termed a government of laws and not of men. So in this case, John Adams had appointed Marbury a judge, federal judge in the District of Columbia, and James Madison, who's the Secretary of State at the time, refused to give him his commission papers. And since this was illegal but correctable, Marbury argued, and the court favored in that they could do everything possible to make this situation right, which is why in Cannon versus the University of Chicago, that's what they tried to do based on the precedent of this case, was to go back and fix the wrongdoing that had been done because it was an implied right of action. The United States basically a representative for the United States, however, maintains that whatever traditional presumption may have been, it has disappeared in the succeeding decades due to the J.J. Case Company versus Borak. The court adhered that the general rule that all appropriate relief available in an action brought to vindicate federal right when Congress has given no indication of its purpose with respect to remedy. So this is the same thing that all these previous cases that I've talked about are following. Because Congress didn't say that no remedies would be available, then we have to imply the fact that they would be available. A representative for the United States argued that this belief went out the window with the Davis versus Passman case. The court dismissed this argument from a representative of the United States because he was basing his argument from this case that covered whether or not what parties could receive remedy, as to where the Franklin versus Gwinnett County case was talking about what type of remedy they should receive. So now, after discussing all these cases, and there'll be some more that we have to discuss here in a minute, but we have to address whether Congress intended to limit the application of this general principle in the enforcement of Title IX. The general rule is basically that if there's an absence or clear distinction to the contrary by Congress, that no remedy should be applied, then we have to assume that remedy should be given to the complainants if the court rules in their favor. And since Cannon versus the University of Chicago happened prior to the amendment of Title IX, and this ruling was set before, we have to assume that Congress did not intend to limit the remedies available in a suit brought under Title IX because of how they ruled in favor of Cannon, which is the implied right to action. The defendants in this case had three main arguments. The first one was that respondents argue that an award of damages violates separation of powers and principles because it unduly expands the federal court's power into a sphere properly reserved to the executive and legislative branches. Basically, they're saying that with the court, the judicial branch, trying to rule in favor of the complainant here, they would be overstepping in their separation of powers. Their second argument, or their second main argument, the defendants tried to say that basically the Congress spending clause was where the money would come from for Title IX remedy, and that's not what the spending clause was there for. The court dismissed this. The defendants tried to use the Durain back pay remedy, which happened in 1963, to defend their argument. But the court said no, that since this was an intentional violation of Title IX and not an unintentional, which the spending clause power does not, the spending clause does not cover unintentional pay, but since this was intentional, that it would have to come from their treasuries for intentional violations of federal statutes. Their third argument was that Franklin should not receive a monetary settlement or monetary remedy because this happened in the past. Basically, they didn't want to go back and back pay for something that happened previously. And since Andrews was no longer a teacher there and she was no longer a student there, they felt that this was like an inadequate argument for the court to rule in favor for them. The court responded with this administrative action will help similar cases, both then and in the future, help complainants through Title IX, seek a monetary remedy. Basically, to sum it up, Franklin and her family won. The district court first denied it, the appellate court denied it, and then the people above the appellate court said, well, we're going to reverse your decision, so you might as well go ahead and do it, and that's what they did. And this set the precedent so that now any Title IX case that rules in favor of the complainant, when they're seeking some type of remedy for it, they can be awarded that because it is an implied right of action that was set by the Cannon versus University of Chicago, which set its precedent on all these other cases that we just discussed. This is important to know as an athletic administrator, basically mainly to me for the intentional violation of Title IX. If you intentionally violate, like the school did, they tried to cover it up, or they didn't want to make a big deal about it or make a scene about it, so they tried to wash it under the rug. If this were to happen and you were an AD, you're a part of the school district that allowed it, and basically the school is going to have to pay out if this happens, which would not be good for your job if you were the one. It kind of goes back to this whole Baylor thing that's going on right now. To me, that's what I think of when I think of this. You can see the AD is no longer there. The president is no longer there. It's been a big mess. And the head football coach, of course. But because all of these Title IX issues and issues of sexual discrimination were swept under the rug, these girls at Baylor can now seek a monetary remedy for the damages that they've suffered.